I'm Becca Roskill. I'm a course assistant at Columbia and a research assistant on the casual payroll. And I am also a member of BC. I'm one of the few undergraduates who is I'm sorry, I'm the only undergraduate who's on the bargaining committee. But as an undergraduate, I'm sort of subjected disproportionately to this different pay scheme, which means that for doing the same work, the same sort of instructional and research work as graduate students, and some of my colleagues who are undergrads as well in different departments, I am casualized, and as a consequence of Columbia's recognition proposal, I would be cut out of the bargaining unit. So on the heels of our last rally, we had a bargaining session and had many exciting wins: third-party neutral arbitration, wage increases across the board, pay parity, dental for PhDs and dependents on and off appointment, and more. But we are still very far apart from Columbia's proposal on this one key demand: recognition. So this is what we're here today to talk about. Now, if you didn't get it from the video, what is recognition? Recognition is what determines the scope of our unit and who is included in the agreement. So even though some of the economic aspects of our contract, like wages and health benefits, are sort of irregardless of whether you're included in the unit, there are PhDs who are not workers, or PhDs who are not on appointment who will be receiving benefits, and there are workers who are on the casual payroll that wouldn't be included in Columbia's recognition proposal, who would be receiving the wage increases. So this is why it costs literally $0 for Columbia to just give us our recognition proposal right now. There are still some really key benefits that people would be carved out of that are essential protections that all workers, especially those who are already certified in our unit, deserve. This is one of the ways that Columbia knows they can weaken our union, by dividing workers who are doing the same sort of work. And we've seen it in other workplaces, right? A lot of workplaces are fighting right now over tiered systems of workers, where some have better protections, some have better benefits. And one of the ways of driving labor costs down is by only appeasing the people who have been around longer, only appeasing the people who are sort of at one end of this tiered system, so that we've seen that more and more people end up being driven into the lower category. So we are here to fight for every member of our unit having the right to grievance and arbitration, to enforce protections across this contract. And I'm not the only one who is sort of at the lower end of this two-tiered system. And there are other casual workers, not all of them undergrads, who are also going to be cut out if we accept Columbia's proposal. So I want to introduce. Oh, sorry. Messed up the order of everyone. I think the first speaker that we're going to hear from is Rithika Ramamurthy, who's the president of Brown's Graduate Labor Organization, and they're going to speak to us about the importance of recognition for enforcing the provisions of a contract.
My name is Rithika Ramamurthy. My pronouns are she, her, and I'm the president of GLO-AFT 6516, the Graduate Labor Organization, the grad union at Brown University. I'm here to tell you that the toughest union fight is the first one. It's the fight to be recognized. It's the first struggle that a group of workers takes together, and it's the last time that the boss will ever be able to speak to you ever again in a shop without negotiating a collective bargaining agreement. So the best is yet to come. I just want you to know that. Grad workers here at Columbia are doing something really incredible right now. I was really struck to see the parameters of your recognition fight because of how much it hits home for us. They're refusing to let the boss define what a worker is. Never mind if someone works 5 hours for the university or 20 hours a week for the university. They deserve the protections of their union contract because they do work for the university, and that work makes the university money. This is a monumental struggle because of what labor in academia has become. Most of you probably know that the past 50 years have witnessed a steady, systematic attack on the security of labor within higher education. Universities have responded to recession and decline with austerity and casualization. They've resisted unions, especially at yours and at mine, at private universities, at every turn, taking advantages of the weakness of labor law and the loopholes in the NLRB to deny workers protections. The Economic Policy Institute has shown that most of the failures of union fights happen because of boss manipulation, like closed door meetings, and exploitation of the sort of like weak protections that workers have to even do the tough work that you're doing right now. Why do they do this? Because they know that there is nothing more dangerous to the obscene wealth and administrative apparatus of higher education than thousands of workers standing together and demanding to be recognized on their own terms. We won a contract at Brown a couple of years ago that protected grad workers doing TA, RA, or proctor work for the university at 20 hours a week per semester. This was a huge win. Thousands of workers would have benefits and protections that they never had before. Grads in some departments saw their salaries double, and others had recourse when they were intimidated and harassed through our grievance procedure. But what do you think happened next, less than 2 years after we signed that contract? The university began to systematically increase the number of non-bargaining unit positions. Let me be clear, this means that where they might have hired someone in the past to work, it's not like we clock in and clock out, right? Everyone knows that grad work is this sort of amorphous thing depending on what department, who your supervisor is, whatever. They suddenly decided that instead of hiring someone to work for 20 hours a week with all the protections that a union contract can afford, they would just create that same position that would work 10 or 12 or even 6 hours per week, expelling those same workers for our bargaining unit. This is happening all across the university. And it's kind of a tautology, right? Our contract says a job at the university means 20 hours a week, healthcare, benefits, grievance protections. Their interpretation is to cut jobs and hours, to casualize labor, and to deny more and more workers union membership by saying, well, they don't work 20 hours a week. We're in arbitration over this very disagreement right now, and we do have status quo like you guys do with our pre-election agreement to protect public health master's grads who were unfairly excluded from the bargaining unit, even though they worked 20 hours a week. They were told that they didn't have the protections of the contract, which is absolutely, unacceptable. But winning something in a contract is better than winning it in a courtroom. And that's what you guys are doing right now, is pushing so that this language is included in your CBA. As your video already said, what Columbia is proposing is a two-tier system. Any of you who follow, labor struggles right now know that it's a thing that's affecting workers from manufacturing to nursing to higher education. It is it's a weapon that exists so that the boss can turn workers against each other, giving some protections and other nothing or even less. The boss will always exist in a relationship of antagonism to a workforce. So it's on us to push and to struggle, not just for a good salary or benefits. That stuff can get better and better with each contract. The most important thing is to win terms of inclusion for every worker to have the contract and benefits that they deserve. Everyone is watching you as you take this fight on right now. And we hope to walk our own picket line in a couple of years to demand that our contract looks the same. So get out there and do it so that grad work everywhere is a union job, and do it for the rest of us. Thank you.
Becca, that was great. And thank you for reminding us how leaving a hole in our contract that doesn't protect some workers leaves us all vulnerable. We can't have a backdoor where the university can sneak out union jobs, right? Because we know they will. And next up, I want to welcome, we have one more speaker before getting back to the slides, or two more speakers, I think. Next up, we're going to welcome Sarmad Aakash, who is an hourly worker in the Mailman School of Public Health.
Thanks, Becca. Thanks for having me this evening. As Becca said, I'm a casual hourly worker at the Mailman School of Public Health. And I just wanted to briefly explain from my position and for many of my colleagues at the Mailman School what this means for us. As employees who are working under 15 hours a week and on casual appointment, we're excluded from the unit. And for me, this is most concerning because in cases of discrimination, which have unfortunately happened to me in the past, I'm not protected in the same way that other members of the unit are. And on top of this, as an international student, our visa and our working rights in the US are limited to TA work or RA work at the university. So we're in a precarious situation where we have to either accept Columbia as our employer if we want any living wage while being here as international students, despite them not recognizing us as employees. And so for me and my colleagues in this situation, recognition is imperative. We've been striking for the last 8 weeks, and this would really constitute a humiliating outcome for us if we weren't able to get recognition. Thank you very much for having me.
Thank you, Sarmad, and thank you so much for sharing your working conditions and why, even though you're doing the same sort of work as others who Columbia is willing to recognize, you would be cut out unfairly. We're going to hear from another worker, Gloria, who's going to share why she's also susceptible and workers in her department are also susceptible to being carved out in Columbia's most recent recognition proposal.
Fantastic. Thanks so much, Becca. Can you all hear me? Thumbs up would be great. Awesome. Thank you. So my name is Gloria, who or Graf, either or. I am a second-year PhD student in epidemiology, and I also did my MPH here at Columbia. So I've been here for about 4 years now. So I'm here today to speak to the importance of including all student workers in the unit with teaching and research duties as someone who's been both a casual worker and been on appointment. So while I'm currently working on appointment in the Mailman School of Public Health, I worked as a casual research assistant for the same PI, for the same supervisor during the second year of my MPH. And I want to be really clear that as I can about this, like whether I was salaried or paid hourly, I performed the same duties. I maintained the same relationships with my coworkers and colleagues and administration. And maybe most importantly, I was subject to exactly the same inherent power dynamics present in any employee or employer relationship. And that's why, this is why all workers at Columbia deserve protections rather than being subject to really what amounts to administrative whimsy about whether we're in the unit or not. And it really brings me no joy to say this, but I want to bring up that Columbia is far and away the most unprofessional employer that I have ever encountered. Before I came back to grad school, I worked in industry for 4 years. I worked in consulting and I worked for 3 different pharma companies. And I have never encountered such complete disregard for paying wages on time, for ensuring that contracts are renewed in a timely fashion, and and I have never encountered an employer who is so absolutely content to fudge working hours for administrative purposes. And I bring this up because I think in a lot of ways sometimes we like to romanticize higher education when I think the reality is the exact opposite, where Columbia takes advantage of its status as an academic institution to not provide the protections that many workers in the private sector would receive, and they hide behind this. So the things that I mentioned, late pay, late contract renewal, fudging hours, these are all things that I witnessed as an MPH student, and they're things that I continue to witness on a regular basis. This past semester, Columbia made a major error on my payroll. This error took over 4 months to resolve, during which I was repeatedly lied to and stonewalled by HR. And at the same time, I was asked to keep over $13,000 in my bank account in case they wanted to reverse payroll and correct this error. I had to keep 6 months worth of paychecks to have any chance of having it resolved, essentially. So I think really what I want to say here is that all workers need protections, because I have entirely lost faith in Columbia as my employer to do right by me unless they are coerced to. And I think a lot of us share the sentiment that we hate being in this position. We don't want to be in an adversarial relationship with our employer. But as the past 6 months have shown me, organizing with a union and also in my personal experience, workers will not be protected unless they are in our unit. And that's why I'm fighting so hard for the inclusion of all workers. Thanks so much.
Thank you, Gloria. So we're going to get back into some of the details of recognition, and we're going to really focus on the aspect of recognition that Rithika was enlightening us on, which is that it's so very difficult to reverse when you've already carved workers out of a decision that has been made. You set a new precedent. And Ethan is another member of the bargaining committee who works with me on recognition, along with the many members of the recognition working group. And he's going to tell us a little bit about the legal decisions that have led us to this point.
Thanks, Becca. Yeah, so I'm Ethan, fellow member of the SWC bargaining committee. So the first thing I want to talk about is just what the certification decision is. So if you're not familiar with what this is the decision given by the National Labor Relations Board certifying our organization as the exclusive representative of the employment interests of employees in a certain classification. And so the decision outlines what the scope and composition of that bargaining unit is. This text that you see here is a text that was initially petitioned before the NLRB by our organization, the UAW, in 2014. And there's a long protracted process that I'll try to sort of briefly go through about how that came to be and how we won that decision. But first, I just want to sort of be clear about what this text is and what it says. So we can go to the next slide. We'll see this sort of magnified. So what does it say? I'll just read it out. All student employees who provide instructional services, including graduate and undergraduate teaching assistants, which is teaching assistants, teaching fellows, preceptors, course assistants, readers, and graders, all graduate research assistants, including those compensated through training grants, and all departmental research assistants employed by the employer at all of its facilities. And then it just lists the facilities and provides some standard exclusions that the National Labor Relations Act stipulates. So these are specific titles, roles, functional roles, employees who provide instructional services. All of these people were certified to be included in our bargaining unit. And so this text is currently what governs who's in our bargaining unit right now, ever since the NLRB certified us, ever since we held an election and our organization was chosen to represent the employees who voted in that election. Now, if we go to the next page, we'll see a proposal that we had that for a long time we had passed to the university for a recognition article in our contract. So once you establish a first contract, you can have a recognition article which can supersede the definition of the bargaining unit in any certification decision because it's voluntarily arrived at by the parties. And so here, what we wanted to do with the language we crafted is to make sure as many student workers who share the same community of interest and have the same interest in bargaining with Columbia, we wanted to make sure that we're able to work together and we're able to reinforce each other's interests through the process of collective bargaining. And so what we've done here, we've sort of just spelled out a stipulated definition of our bargaining unit along the lines of the NLRB certification decision. You can see this first highlighted section. This is Roman numeral 3. This connects the definition of our bargaining unit to a titles and classifications article, which would similarly provide sort of a table connecting specific titles to job duties. And that would provide some protections against the university, introducing new titles not in the unit, but with the same duties in an effort to undermine the composition and scope of our unit. And we've also provided in section 3 here sort of a similar protection against the process of casualization, insofar as that can undermine our unit by introducing people who are not connected to it. So this is the language we passed for a long time. And now on the next slide, we'll see this is Columbia's proposal. And this proposal is more or less what they've insisted on since the beginning of the collective bargaining process, with sort of a minor modification. But you can see here, for one thing, they're explicitly excluding student workers who are enrolled at affiliated institutions. So that would be like Teachers College or the seminaries that have this very close legal relationship with Columbia, and that contain student workers who frequently fulfill teaching duties at Columbia University classes, right? So it's common for student workers at these places to be working for Columbia as teaching assistants, as instructors of record. Columbia wants to exclude all of those people, despite the fact that the NLRB certification decision is not exactly clear with respect to that question. So they want to preempt that question. They also significantly, and you can see this in Roman numeral 2 here, they want to impose an hourly threshold to exclude what they're calling casual employees, including course assistants and graders. And this is despite the fact that the certification decision doesn't impose any sort of asymmetry between, for example, course assistants and teaching assistants, or between graders and readers. But Columbia wants to impose this so that they can essentially, deprive our unit from people who are currently recognized as being part of it. And this is not something new, right? The desire to push back against the NLRB, to push back against certified decisions made by courts of law, this is not something new. And so now I want to very briefly go through Columbia's history of union busting. It's actually quite storied. It goes back 70 years. They're one of the pioneers in higher ed labor busting. And so on the next slide, this is just a very brief rundown of the history of labor organization in higher education. So one of the very first important cases was actually argued by Columbia in 1951. They successfully argued at the time that student workers should not be entitled to labor protections. And that precedent stood for around 20 years until it was reversed in 1970, allowing student workers at private schools to unionize. By the way, meanwhile, student workers at public schools have long enjoyed this right, because those sorts of employment relationships are typically governed at the state level, where there are different rules about who's allowed to engage in collective bargaining. So this all has to do with private institutions like Columbia. So the NLRB has sort of gone back and forth. They've vacillated over the years, over the decades, about whether or not student workers have employment rights under the law. In 1972, it went back. In 2000, in the NYU case, again, they sort of reversed. And then in 2004, they reversed again. So they've sort of gone back and forth, sort of depending on the composition of the National Labor Relations Board. It's sort of interesting to note that in all of those cases, Columbia has filed, amici brief about, expressing their interest in not having student workers recognized for the purposes of bargaining. So what happened in 2014? We petitioned the National Labor Relations Board with that certification text because we wanted to be able to bargain collectively. In response, the National Labor Relations Board said, okay, we want to hear this, we want to revisit maybe our decision in Brown. So let's hold some hearings. And so that's what happened. They scheduled hearings where our organization was able to cross-examine certain officers at Columbia in order to gain information about whether or not we should be considered employees. Sort of one of the main arguments they made as it pertains to casual workers was that, well, look, we have this sort of casual payroll, and this is different from the way that we pay other employees' salaries. And so, they wanted to argue that this casual payroll was a justification to deprive labor protections from people on that casual payroll. So you can see here a transcript from that hearing where they sort of make this argument. In the next slide, though, so interestingly, though, at that same hearing, they provided a lot of information that spoke against that. Essentially, the casual payroll is a fiction. it's not really a substantive difference for Columbia, whether or not you're on this casual payroll and compensated as a course assistant, or whether or not you have an appointment as a teaching assistant. And that came out very clearly in this hearing. These 4 points were all established by Dean Kachani, an officer of the university. It was established that both course assistants on the casual payroll and teaching assistants, they both provide the same instructional services. They both work for identical periods of time per week, 8 to 15 hours. They both received the same exact payment, total compensation. And historically, the university has not carefully distinguished these roles. The people have been given a course assistant job, but they're on the books as a teaching assistant, or they've been given a teaching assistant job, but they're on the books as a course assistant. These categorizations are very fluid, and there's sort of no rhyme or reason why someone is paid from the casual payroll or paid from a salary, other than that they're trying to use the casual payroll as a pretext to cut people from the unit. Now, eventually in 2016, in a landmark decision, the NLRB reversed the Brown decision, allowing us to unionize and ordering an election for our bargaining unit. So we had that election. Overwhelmingly, people in the bargaining unit voted to authorize SWC as the collective bargaining agent for this bargaining unit. Immediately after, Columbia disputed the election. They tried to appeal to federal court, as is their right, but they refused to bargain throughout this whole process, despite the fact that the NLRB had definitively ruled that we're student employees, our election was valid, and they have a duty to bargain with us. What happened was we went on strike because that was our right under the NLRA. So we went on strike and we got Columbia to sign an agreement called the Framework Agreement that was signed on November 19th, 2018. And so this agreement required Columbia to recognize our union as the collective bargaining agent for our bargaining unit. And you can see here the language that was used, right? So Columbia will recognize the Graduate Workers of Columbia, that was our former name, as the exclusive bargaining representatives for the individuals included in the 2 respective NLRB certified bargaining units. So it makes an explicit reference to the NLRB text that we just looked at before. In spite of that, ever since that agreement, Columbia has refused in any putative contract reached between us and them to maintain their recognition along the lines of the NLRB text. And we have been consistent since the beginning of our organization, since the beginning of all of our campaigns, that recognition is a crucial issue for our unit. We reached a tentative agreement in the spring with the previous iteration of the bargaining committee, but that agreement was not ratified, which to my knowledge is the first in higher ed unionization. The contract was rejected, and a significant reason based on surveys of our unit for its rejection was its lack of full recognition. It had the proposal that I shared with you before. It had Columbia's language that would exclude people below this arbitrary 15-hour threshold. And so that's not acceptable to us. It's not acceptable to us not only because it will immediately cut out a significant portion of our unit, but because we've seen throughout this long history that Columbia is willing to do whatever it takes to undermine our bargaining unit, to undermine unionization efforts. So, we don't want them to now move everyone below that threshold as they easily could do, right? So we now see we're at the table with Columbia after 3 years of bargaining. They continue to refuse to agree to the scope that is currently the law. We're also seeing that there are various interests within the university who don't want to recognize these workers specifically because they don't want to provide them protections. And that's completely unacceptable to our membership. And that's why we're fighting so hard for recognition, because we know that this is something that's more or less permanent. Once we come to an agreement with Columbia, once we voluntarily allow Columbia to set the terms of our bargaining unit, it's very, very difficult to go back from there. And that's part of the reason why we've wanted to come to a compromise with Columbia. We understand they have a certain interpretation of the NLRB certification decision. we have a certain interpretation of the NLRB certification decision, but there should be no disputing that the certification decision is valid, regardless of what your interpretation is. That is the law, and it's something that Columbia agreed to explicitly in 2018. We just want to hold Columbia to that promise, and we think we're well within our rights.
Thank you, Ethan. That was a lot to get us through, but leave it up to you to make this legal stuff still sound exciting and make it obvious how it's so pertinent to the struggle that we're going through right now. I want to next welcome Brandon Mancilla, the president of the Harvard Graduate Students Union, our brothers and sisters in UAW, Local 5118.
Hey everyone, thanks for having me. Just want to start off by saying, expressing our solidarity with your struggle, your strike, and how close you are to signing a landmark agreement that will set the terms for higher ed, private higher ed for the next few years. I think the specific issue, at stake here and we're talking about is absolutely crucial. I wanted to say that we have strong language on this in our two contracts, but in fact that would just be misleading because it is just a status quo language, and even that has made all the difference. As Ethan started pointing out, but I can speak to in practice, even with the language that you're trying to fight for and will eventually win, the game plan of the university employer once the contract is ratified is to start poking holes in the bargaining unit, reclassify workers, create new worker positions, and then also contest anyone who they deem ambiguous and would like to not be included in your membership. And this is with strong language or your status quo language. And this is true, for us at Harvard, for other higher ed unions, with Brown, obviously is going to arbitration over certain similar cases. But it's also true in many other industries. We see new positions, new contingent kind of precarious positions created all the time to go around the question of whether or not they should be included in a union membership or not. I think also the School of Public Health deserves a shameful shout out. In both of these cases, it is with the School of Public Health where we've seen most of these issues. So now at Columbia and also over the past 3 years at Harvard. I guess you can maybe start unpacking where we are with the pandemic, if this is how public health administrators think about labor. And this week, I think that resonates more than other weeks, if it hasn't at all during the duration of this pandemic for you before. So I guess I'll just go into a few specific instances of things you can expect even with the language that you want to win and do win, and why having that language is absolutely crucial in contract enforcement once you do have a contract. On the issue of who is in the unit or not, you can expect reclassifications of workers, right? This shouldn't matter because the language is clear that this contract, this agreement would represent workers who do any instructional services and any grad research assistance. But it'll be direct strategy from labor relations or from HR or your equivalent office to essentially overlook that and try to argue that new kinds of workers were not what was, they were not included in the bargaining unit, and they were not folks who, were meant to be represented by the union in under this contract. At a possibly more sinister level, I think this then gets translated in a way in which department level administrators or folks who honestly are just doing their job, right? The normal just guys going day to day, working in the payroll office, doing department level data entry. They won't get proper guidance from HR or labor relations about how to actually enforce this contract. So they will make the mistakes of actually going forward and in reclassifying workers and deeming workers, non-eligible for sort of union representation because they actually haven't been told by, a direct mandate probably from the university that these folks are not actually in the unit. We have seen this happen, especially with hourly workers in a number of departments. We have had cases, the most recent one was in government, and I guess our political science department, we have a government department, where almost monthly we get new hourly workers come forward who talk to our grievance committee saying, why weren't dues deducted from this week's paycheck or this month's paycheck? And then we go look into it, and then suddenly we realize, oh, these folks were not included in the worker list because this was a brand new RA position created for this under this grant or under this supervisor who has never actually hired people for this kind of research work before. Again, that shouldn't matter, but these are the kinds of things that happen because folks aren't getting proper guidance. But because we have a contract with strong language on this, so we can say all grad research assistants are covered under this, then they have nothing to say or will file a grievance. The biggest case we had to fight this past year was in the School of Public Health, which I mentioned already, in which the School of Public Health, which fought us, Ege can talk a little bit about this later, for years on having the same raises as other folks and who would receive the same raises as folks in arts and sciences and engineering, et cetera. They started reclassifying, or actually not reclassifying, they started to argue that workers, TAs or TFs, who teach for credit, for academic credit, are actually not student workers. Now, these teaching assistants do the same work that a teaching assistant in English or history or math or a course assistant, an undergrad course assistant does in computer science. But because the school determined, or the department, was in particular the population health science department, because the department determined that academic credit mattered more than, or didn't matter more, but wasn't actually labor, then these folks weren't covered by our contract. We filed a grievance over that. We took it through the grievance process. We filed arbitration, and right before arbitration, we were able to settle that issue. And we were able to settle in large part because they saw that we weren't going to leave these workers behind. And workers in population health sciences and the School of Public Health more broadly started organizing around this. And essentially, the School of Public Health then restructured its entire PhD program so that it could match up with essentially the Graduate School of Arts and Sciences structure. And now folks who teach, regardless of whether it's for academic credit or not, are going to be included. And well, they always were, but now the university admits that they are part of the bargaining unit, just like any other teaching assistant is. This issue has gone beyond the School of Public Health, or even specifically the Population Health Sciences, the School of Public Health. It's gone into other departments, some departments in our medical school, a few social science departments. And again, it's much harder to carve out folks who are in the Graduate School of Arts and Sciences. But the idea is simple. If they can get away with the argument that teaching for academic credit, so let's say you have to teach in order to graduate with a PhD, if they can get away with that argument, they will keep trying it. And we have stopped them from getting away with that. Obviously, there's nothing wrong with teaching for academic credit. We should all be better trained to be good teachers, to be better instructors in the classroom. But that is not a replacement for bargaining unit representation and membership. That is labor. Labor is labor, no matter who you're doing it for, how you're doing it, how many hours you spend on it, and what, even worse, what classification the department or the school has determined you work under. So that has been our line the entire time. So we've had to fight cases like this in the law school, in evolutionary biology, in biomedical sciences. I can go on. And in every single case, the university has had to admit that they're in the wrong, they will fix this, or we'll go to arbitration. And that has been what they're most scared of, because again, I think Brown is going to prove this if they actually go to arbitration. If an arbitrator rules in union's favor, which is absolutely what could happen there, that will essentially have to stop them from continuing these kinds of practices. So we are also looking into arbitration as a possibility for some of these cases, because again, we want to set the tone and a precedent going forward that just because we sign status quo language doesn't mean that we are going to continue to allow the university employer to try to work around it, and we're going to keep them in check. So yeah, there are many other grievances that are based on this issue, this fundamental fact that the university is going to just continue to try to get around the contract. And that's why strong contract enforcement is absolutely crucial, and having the best possible language in place is going to be the thing that is going to be your biggest weapon. The university won't care about the contract language in terms of enforcement. They're not going to try to, their goal from now on is not to actually enforce the contract. It's our responsibility as a union to keep them in check and to use the contract to fight for our rights. So yeah, I can go on, but I think how we got here is probably going to be really important. And I think A is going to go into a little bit of that about how it is that we were able to just get that basic language in the first contract in the first place. But yeah, the one thing I just wanted to get across was, even if you get the language you want and demand and win it, you're still gonna have to go fight for enforcement of that language, because the university is not going to stop in its tracks, especially if they've already revealed that that's precisely what they want to do. They want to get away with 15 hours as threshold. So contract or no contract, they're going to try to do that, and it's going to be up to all of us to make sure that that they don't get away with it.
Thank you, Brandon. And thanks for emphasizing to all of us that getting this contract is just the first step. We have a long fight ahead of us in enforcing it. And right now what we're trying to do is prepare the strongest fighting ground that we have. Okay, perfect. In the meantime, we're just going to finish up our slides, which have one more short section on why exactly we fear the casualization of our unit, and more broadly in the sector of higher education. So we know that casual workers are more vulnerable. Any worker who is depending only on his relationship with his employer is vulnerable to trying to fight through a struggle that by nature needs to be fought collectively, all on their own. And we've seen in practice that casual workers are the workers who are encountering the worst infractions, and sometimes don't even know that they have a right to be protected against these things, whether it's late pay, discipline and discharge, so undue firing. All of these things apply to casuals as they apply to salaried workers, and it's just as important to protect against them. Next slide. So our sector is especially susceptible to this two-tiered worker system because this is within our own unit. So the sort of work that I do, and I can speak to both the instructional and the research aspects of this, as I'm a casual instructor and I'm a casual research assistant. A lot of our job responsibilities, as you can see here in this sort of grid of what the job responsibilities are of salaried workers versus casual workers, are exactly the same. We all do the same kind of work. It's really just a decision for which of these categories the university decides to put on your hiring papers. And depending on that, it could screw you out of a union as is. And we want to make sure to protect against that. When people are doing the exact same work, it seems very obvious that they need the same protections. And just to really drive home how sort of arbitrary this distinction is, when I get my instructions for how to log time over the course of the semester, I'm literally told that I'll be paid a stipend of the amount that I get paid per unit for the semester. So a class is 1 unit. So per class, I get paid a certain stipend. But am I a stipended worker? No. I'm an hourly worker because I log hours to collect that stipend. Which hours? Exactly the hours that they tell me to. Each day, and I can't go off the book because I need my professor to approve these hours. And this is how they enforce the casualization of positions that earn a regular stipend to hourly positions. It's already happening. And we're getting ourselves into this vicious cycle if we keep allowing it to happen. We know that Columbia is catering to its students, its customers, in the sort of commodified model of higher education that Columbia perceives. Students are a way for them to make revenue. So what are they going to do? They're going to enroll more students. And then they have over enrollment. So they need someone to carry the workload. They don't have time to retroactively get more tenure track professors. That takes years, it takes a whole tenure track. So what do? They hire casual workers, and then they get into a position where they're administratively prepped to have casual workers, and it's all they can really support. It's what they're used to. It's the labor costs that they've gotten used to, and they see that this is a form of cheap labor, and they don't want to go back to a form of more expensive labor, right? So in this situation, now they're ready to enroll more students, and we go again and again through this cycle. This issue isn't going away. We need to stand united with other workers in our sector, whether it's faculty or adjuncts, clerical, dining and facilities workers, if we want to protect against this vicious cycle. The only thing that we can do to start fighting our way out of it is use the impressive power that we have right now. So next up, I want to invite someone who might be one of the most appropriate speakers to teach about vicious cycles that characterize our economic system. Richard Wolff, thank you so much for being here with us.
Thank you very much for inviting me. Let me begin by telling you, because you can see from my hair that I'm older than you are, that I am honored by your invitation and that I'm inspired by everything I've just heard, by your leadership, by your courage, by your willing to fight back. You are not just what Columbia needs, you're what this country needs. You are heroes and heroines, and at least as one person in the academic world, I've been a professor all my adult life, I am immensely impressed by what you are doing. And any way that I can help beyond today, please feel free to call on me. Let me give a little context to what you're doing that may not have occurred to you yet. Here are some statistics to think about. We have seen more people quit their jobs in the last 6 months than we have ever seen in American economic life. Coming back from the pandemic, coming back from the unemployment that we have suffered over the last year and a half, workers by the millions have quit their jobs. Millions of people have retired before 65 because they can't stand going back to the jobs they had and the way they were treated. They quit. They retired. That is one way of dealing with the kinds of problems you're dealing with. But I prefer your way. And I don't think the problem can be solved if you quit or you retire, because that doesn't change the situation. It leaves the situation with those who couldn't quit because of their family conditions, their personal circumstances, and who couldn't retire. What you're doing is fighting, and fighting to make these jobs fairer and better. And that's what the country needs, and that's what you're doing. You have a different reaction to a system that is oppressing you. I've spent my life in institutions like yours. I went to Harvard, I went to Stanford, and I went to Yale. I'm like a poster boy for what this country calls elite education. And I've been a TA and I've been an RA. It's long overdue what you're doing. You are beginning to correct generations of abuse to make more money for institutions that present themselves as educational, as nonprofit, as committed to civilization, as embodying the greatest values of the society. They are none of those things. More than ever today, they are business propositions run by business people on the logic of business, making money and abusing you because it's profitable to do so. Nothing personal, it's just business. But you know, the labor movement is awakening. We've all been waiting for it. You're part of that. This summer, Americans saw the workers at Kellogg, who make our cereals, the workers at Nabisco, who make our cookies, the workers at John Deere, who grow everything in this society that comes from the land, and much else. And I could go through a much longer list. They're all striking. They're doing what you're doing. They're fighting back. The John Deere workers rejected several of the contracts brought back by their leaders because they weren't good enough. And in the end, they got it all. Fighting is the way to go. And one last way to understand that, if I can leave you with it, is to tell you that there was a time, less than 100 years ago, the 1930s, a depressed economy like now, a depressed society like now. But then the working people did something no one expected. It took a few years. The crash happened in 1929, and the labor movement didn't get going for several years. But when it did, it moved the way you are. And I want to link you to it because it was the greatest movement, not just for the labor movement in this country, which never did as successful a unionizing drive before the 1930s as it did then. And sadly, it's never done it again since then. But let me remind you what happened. In a matter of 2 or 3 years, once the breakthrough was made by courageous early people, just like you and the people at Brown and the people at Harvard. Once it got going, it was like the proverbial prairie fire. Tens of millions of Americans who had never been in a union joined one. It was spectacular. And they merged with social movements, progressive social movements. In those days, those movements had daring names: 2 socialist parties and a communist party here in the United States. And together, those progressive social movements and the CIO, that was the name of the union drive then. Let me give you a short list of what they accomplished, because you are at the beginning of doing the same thing. They achieved the Social Security program. We never had that in America before. You're 65 years of age or older, and in honor of a lifetime of work, we give you a check every month for the rest of your life. Conservatives have tried to undo that and have never succeeded. That was won by the unions and their progressive allies. The first unemployment compensation program in American history was won in the middle of the 1930s. The first minimum wage ever paid in the United States was won in the 1930s. And a federal jobs program for the unemployed, 15 million were hired by the government. Yeah, all of that was done by an alliance of the union movement, the socialists, and the communists. That's American history. It only took a few people at the beginning to break through where the breakthroughs hadn't happened. That's what you're doing. You've been doing it at Harvard and Brown. You've been doing it at Columbia. And you are going to inspire others as others are moving just like you. It's a remarkable, really remarkable time. But if American history is any guide, you should be very, very excited, because you are learning, as I've watched you today, how to fight. You're understanding that Columbia is part of what makes this country the mess that it is. The socially divided, disastrous, unequal, rogue country in the world. That can only be changed from within. And that's exactly what you are about, even if it's a little scary to think about it. So my hat is off to you. You are doing the most important political action this country needs now, even as you fight for recognition from one of the stalwarts of the status quo, which Columbia has always been. And you're doing it in the full glare of New York City, where no one will miss what's going on. My final thought, I do a weekly radio and television program that goes into 55 million American homes. My opening segment on next Monday's program will be about all of you and what you are doing, because I want to spread to others the enormous achievement that you already represent. And I'm looking forward to hearing about winning that recognition. You've made a wonderful case for it. And just know there are people out here watching you who are really blown away by what you're doing. Thank you all.
Thank you. That was simply inspirational. I wish we weren't on Zoom so you could hear everyone clapping and cheering you on, because I'm sure everyone is behind their own little cameras. I'm going to ride that wave of inspiration that you've created for us to call upon everyone here to get involved and help us out in any small way that they can. So here on the screen, you can see a few ways that we're asking you to help us out. You can contact Columbia administrators, and in the graphic to the left, you can see all the contact information, whether it's by email or by phone. We also have a petition. Maybe someone can drop the link in the chat. We would love it if you signed that. We have a ton of signatures already, and we want to deliver this to the administration if they don't grant us the recognition that we deserve soon. You can post on social media and shout us out in other venues like Richard Wolff has offered to do. And you can donate to our hardship fund, which is the best material way to help us stay on strike and keep up our power. We've been on strike for 9 weeks, and it's not easy. People are really struggling at this point to keep going, and it's only the hope that and the knowledge that we deserve something better that keeps us fighting. So please donate to our hardship fund and help us support people who need it. And finally, we want to specifically call on faculty to raise your voice if you understand why this issue is important. Columbia is arguing right now that faculty disapprove of casual workers having workplace protections. So please let your department chair, school deans, and the administration know that you and other faculty support recognition. That opposition to this isn't coming from faculty, but just the opposite, that you support all workers having the same protections, because if some workers need it, all workers need it to do the same sort of work. Thank you all so much for being here. I want to circle back and give Eggy the chance to speak if you want to, since I know I cut you off.
Totally fine. Can you hear me now?
Yeah, you sound great.
Yeah, so sorry about my connection. I'll just keep it brief. I shared the regional decision with you guys on the chat. Just to, add to Brandon's points, we've been fighting the recognition fight for a really long time, and we're actually still fighting it because we signed a contract with an open shop at Harvard first year, and then now for a much longer contract. And that has created an environment in our union where we're still fighting for our recognition. Universities haven't moved off from thinking of us as not workers. And until we secure every structural measure from recognition orientations to union shop, recognition fight is not gonna end. And I believe we're a movement because we learn from each other. It's really hard not to make mistakes because there isn't much precedent in, the context of everything that's going on. So I hope you guys learn from us that giving in structurally is a bit of a death sentence in many ways. We learned that. We're continuing to fight. There's no shame in trying and losing a little bit in a fight. But if we don't learn from each other, then we're fools. So in this hellscape, we're looking at you to, get a better deal so that we can get back to fighting at Harvard as well. And yeah, we believe that you will win. There's no argument they can make at this point to not let you have the recognition that the NLRB certified in many years ago at this point. So thank you for fighting for all of us.
Thank you, Ege. And I think we all agree that if Harvard can go by the Columbia ruling, so can Columbia itself. So thank you so much for being here. And it's certainly true that we all need to keep pushing the ball forward, not only for ourselves, but also for workers across our sector. If you haven't already done so, whip out your phones, email one of the administrators. Tell them why this is important to you. Tell them something you learned today. Give everyone a minute to do so. And also just say, once again, thank you so much for being here. It's really amazing to see everyone out here fighting for an issue that is particularly near and dear to my heart. It's really great to see you all here, and especially in the middle of the holiday break.